request trusts need to be declared and constituted. One of the important elements in the declaration stage is the three certainty that consists of certainty of intention, subject matter, and object. In this video, we are going to focus on the certainty of subject matter. Certainty of subject matter directly means that the subject matter of the trust must be certain and identifiable for the trust to be executed. Thus, the trustee must be able to identify with certainty and precisely the trust property which he holds on trust. However, it may be that the property itself is certain but the beneficial share are not. The trust will fail unless the trustee has discretion to determine the amount. In other words, there are two aspects under the certainty of subject matter. The first one is that the property which is to be held upon trust must be correctly identified, and the second one, the beneficial interest of the share of each beneficiary must be ascertained. As for the first aspect, the subject matter of the trust must be specified with reasonable certainty in whatever form it takes. If there is doubt as to it, the trust would fail. In a decided case, which is the Sprunge and Barnard 1789, the trust failed because of unsureness of trust property at the time trust was created.
First of all, the trustee must be able to identify the certainty and precisely the trust property which he holds on trust. There are two aspects of this requirement, and the first one is the property which is to be held upon trust must be correctly identified. This is due to, in some circumstances, the trust property itself is in uncertainty, as demonstrated in the case of Palmer against IMAN. The testatrix wanted to make a trust of the bulk of his residuary property. Next, in the case of Sprunge against Barnard, where a designated beneficiary was given property for his personal use, and in addition, the remaining half of what was left that he did not want for his use to be shared equally to two named individuals. In these two cases, the trust itself failed for being ambiguous. However, in Rigolets-Will's trust, the court decided that the words reasonable income were not intended to allow the trustees to make subjective decisions, but they provided a sufficient objective determinant to enable the court to quantify the amount. In the case of Woolly Development Sdn Bhd against Tiara Contours Construction Sdn Bhd, the Court of Appeal decided that Cherating held the property in trust for the respondent and the appellant got the property illegally as a constructive trustee. So, when the SPA was signed, the property did not exist. The rule is that for a trust to be created by a law, there must be property in the trust in the first place. The proposed settlement and the SPA were just promises by Cherating to pay off the respondent's debts and thus could not establish an interest in land that could become the subject of a trust.
A trust is a connection in which one person controls property, both tangible and intangible, for the benefit of another. Cash, goods, cars, equipment, buildings, and investments are examples of tangible assets, while intangible assets, which include financial reporting, prepaid costs, intellectual property, and reputation, do not exist in the material form. To comprehend the worth of an asset, one must first comprehend its prospective long-term advantages. Intangible assets are frequently more valuable in the long run than tangible assets, since tangible goods depreciate faster, as are circumstances in which an attempt is made to form a trust over a portion of a large amount of physical property. When a portion of the bulk of the tangible property is held in trust, the trust property is only certain if it is separated from the remainder. According to the case of Berg versus Halsey, some of my best linen, Jubel and Jubel, a handsome gratuity, and Recop WT that commanded to acquire blue chip assets were all deemed to be an unclear statement of property to be considered on trust, which resulted to be void. Another legal concept highlighted by the Court of Appeal from the case of SKMNE Persekutu Sdn Bhd and Pembinaan Legenda Unggul Sdn Bhd is that traditionally in equity and trust law, the property must be individually recognizable in order to infer a trust, so that there is a tangible subject matter onto which the trust may be imposed. Similarly, a trust can be formed between two parties to promote a business endeavor when neither party has the legal competence to transfer property. to the other through a contract. The trust property must be in the form of a choice in action, which is an intangible personal property right. In Don King Productions Inc. and Warren, the court used this approach. The court had to decide whether the benefit of the promotion and management agreement could be the subject of a trust, notwithstanding the clear language forbidding the assignment of rights.
As for the second aspect, there are 4 circumstances where the beneficial interest can be said to be certain. The first circumstances is when the trustee are given a discretionary power to fix the beneficial interest to be taken by each beneficiary. Secondly, where the testator has used words which permit the court to determine the beneficial interest. Thirdly, where the court can apply the maxim of equality is equity and divided the property equally among the beneficiaries. And lastly, where the property is given to beneficiaries subject to the right of other beneficiaries to take an uncertain part. The direction as to the uncertain part fails and the principal beneficiary becomes entitled absolutely over the trust property. All 4 circumstances will be explained further later in this video.
The second rule to ascertain the subject matter of a trust is by identifying precisely the beneficial interest or share of each beneficiary. There are 4 circumstances in which the beneficial interest can be said to be certain. Firstly, if the trustees are given the discretionary power to fix the beneficial interest of each beneficiary, the beneficial interest can be said to have been ascertained. Generally, the settlor must determine the subject matter to make the valid express trust, and if the property is defined but did not ascertain the beneficial interest of the beneficiary, the property will revert to the settlor's estate on the resulting trust. However, this general rule is not applicable to a discretionary trust. It is because in discretionary trust, the settlor will authorize the trustee to decide the amount each beneficiary is entitled to. For example, in the case of Frigoli's will trust, the testator instructs his trustee to give his daughter to enjoy one of his flats during her lifetime and to obtain a reasonable income from his other properties. In this case, the court held that the trustees had discretion over which unit the daughter shall receive. Therefore, the trustees were under the obligation to pay her a reasonable income. Next, the second circumstance where the beneficial interest can be said to be certain is when the testator has used words which permit the court to determine the beneficial interest. If the beneficial interest has not been defined, the court will seek to determine the settlor's underlying intention. For example, in the case of Gold against Hill, it was provided that if declared beneficiary shares are unclear, the court has a duty to infer the settlor's probable intention to make the trust certain. In this case, a trust was decided for a mother and children without specified shares. The court then inferred an intention to give the mother discretion on how to spend the money on the family. Other than that, deciding a reasonable income could be identified as a sufficiently certain share of trust property. This has been further illustrated in the case of Rigole Morris against Bridgewater, where in this case, the court looked at the wording reasonable income and assessed it in an objective manner by saying that the reasonable income is not uncertain and can be assessed easily, as the court would not face any difficulty in ascertaining the reasonable income. The words reasonable income provided a standard which could be objectively measured by the court, possibly by looking at the beneficiary's standard of living.
Moving on to the next one, the application of maximum equality is equity. It is to divide the property equally between the beneficiaries. It can be illustrated in the case of Dr. Jayalakshmi Ratnavali and others against Sri Dr. M. Mahadevan and others. In this case, a will was created and the settlor appointed 2 of his brothers as the executors and trustee. The settlor then passed away, then on his will he had mentioned 8 names for the beneficiaries. 6 of the beneficiaries are his children, while another 2 are his wife and mother, which had passed away after that. The executors and the trustee had not acted or carried out any form of distributions as required upon the death of the settlor. The children, which are the 6 plaintiffs in this case, sought for the court to terminate the trust and divide the property equally between them. High Court had allowed the application in order for the trust to be divided, referring to the maxim of equality is equity. But the decision was overruled by the Court of Appeal, which had stated clearly how the beneficiaries has no immediate right over the trust property in discretionary trust. Therefore, we can see that this maxim is applicable unless there are other circumstances that will make it unavailable. The last situation is when the beneficial interest of other beneficiaries is uncertain. It means that when there is a trust created in which the property is given to one beneficiary and other beneficiary will seek to take an uncertain part, but the direction of that matter is not clear, therefore it fails and the principal beneficiary will be entitled to the property absolutely. For example, A was given a piece of land through the trust will, and his brother B was said to take any part of the land that will not be used by A. The certainty of the subject matter is clear, which is the land, but the uncertainty falls on the beneficial interest of the land for B. The direction of what B can obtain is uncertain, since he was said to take any part A does not want to use. Can be illustrated in the case of boys against boys, where the trust property of houses was given to Maria and Charlotte, but only after Maria had chosen hers. In this case, Maria died before she is able to choose the house. Here it can be shown that the direction of subject matter of a trust for Charlotte is uncertain as to which house will be given to her, and if Maria is able to choose the house, the subject matter of her beneficial interest will be certain, since she is the principal beneficiary.
In conclusion, the subject matter is very crucial and need to be identified with certainty. Failing to do so will render the trust fails, as proved by the cases in the discussion. That is all from us. Thank you.